I'm studying this currently in paralegal studies at Hines, and it's very interesting, all the steps that you have to go through.
Yep, it is, and it's a process that probably hasn't changed much in the last 300 years. The way that we do it now.
It must work.
Well, the way that's law changes very slowly, and so the way we do things now are pretty much very similar to the way we did them 200, 300 years ago. Abraham Lincoln would recognize the processes
really?
that we're going through, but not be foreign to him.
Wow. So. Okay. You may have some advice on Emily Hopkins' comment. She says, just put your things in your kid's name. That's simple if you don't want them to go through this stuff.
Well, and that will avoid the probate process, absolutely. So that is one way that some people will try to avoid probate. The thing you got to think through, though, is do you want your kids owning your things? Because once they own your things, it's not your things anymore, it's their things.
Yeah.
And they can do whatever they want to with it. They can spend it, they can give it away, they
Sell
can
it.
lose it in a poker game, they can sell it. They may lose it not because they're bad people and would take it from you, but others may take it from them, like in a lawsuit. And so they get sued because they have late payments on their house, and they get a foreclosure with a deficiency judgment. Okay. Now then that lender can go after anything they own, which is the stuff that you used to own because you transferred it to them. There are also, for some assets, adverse tax consequences to doing that. So giving those assets away like that can actually cost your kids money because they lose some of the tax advantages that are built into the system if you inherit property that doesn't exist if you are given the property.
And in the episodes we've had with you before on elder law and Medicaid law, age may be a factor too about giving their stuff away if they may need nursing home care later,
be.
Right?
Yeah, I mean, sometimes people will give stuff away in order to start that 5-year clock running for Medicaid purposes. Again, there are lots of bad things that can happen. We generally do not advise giving it away to the kids because of so many things outside of your control and sometimes outside of their control. The same would hold true with giving assets away for probate. Most of the time, there are other ways of handling it, again, depending on the asset. Certain assets, like financial assets, can have pay on death designations. So you can be the owner, but it says pay on death to my child.
Okay.
That asset would avoid probate, but you're in charge of it as long as you have a pulse. And so you're not giving it away, you're not making it subject to your child's divorce, not making it subject to your child's creditor. You're still in charge, but you avoid that probate process. Not all property you can do that with, but a lot of the property you can. And so many times we'll avoid probate doing that. Another common way that we will avoid probate, if probate avoidance is important to you, is to create a trust. And generally we call that a revocable living trust, a trust that is what we lawyers would call an inter vivos trust, a trust created during the lifetime of the individual, where that trust then is controlled by the former owner of the property. They will then take that property and transfer it into that trust so that the trust becomes the owner. The former owner then just becomes the manager and the beneficiary of the trust. So when that person dies, again, remember why we have probate, is to determine who owns this. There's no question about ownership. It was owned by the trust while you were alive. It remains owned by the trust at your death. We don't need a probate process for that. We have a successor trustee that takes over. They have instructions in the trust as to how we're going to divide that property out. And so we can handle that privately, quickly, efficiently, and inexpensively without involving some court that knows nothing about you, that you had nothing to do with choosing or anything else, and that many times costs a lot of delay and costs a lot of money. Again, following this archaic system, we can eliminate all that by having those assets owned by the trust during lifetime and just continue to be owned by by the trust at death. And that takes away the uncertainty of, again, losing them to lawsuits and losing them to a child squander. You're not giving up control. You're simply having those assets owned by an entity that is immortal rather than someone that's going to lose a pulse at some point.